Yes, we are very prepared, and we are ready for the hearing on the 9th. It's a very strange exercise we've been involved in. You know, as Peter said, we have worked in many different international criminal cases in arising from events in Rwanda, the Congo, Kosovo, Cambodia, the former Yugoslavia. And in all of those situations, we've had a client. So the majority of our work as defence lawyers is spending time in the detention unit, talking to your client, learning from your client, and getting their instructions. And they tell you what they think of the evidence. They'll say, this is correct, this is incorrect, this is who you should speak to, this is how you should investigate. And so then we have the privilege of going into the field and learning about the crimes in question. That whole aspect of our work has been wiped out in this case because Joseph Kony is not in the ICC detention centre. So we can't go down the road and talk to him and learn from him about how he would want to be defended. And we don't have any ability to try and presume. He might want to plead guilty to crimes. He might want to say, yes, these happened, and yes, I was involved. Or he might want to say, it's important that you know that no, we weren't involved in this particular incident or event. So without that starting point, our work as defence lawyers in this case has been very different. But I can still assure you that we have been working very hard in terms of really focusing on spending as much time as we can here and learning directly from the communities on the ground about the events. And in particular, discussing with them about what this 20-year search for justice should look like and how it should end. And so when we stand up on September the 9th in the courtroom, we won't be doing what we normally do, but we will be prepared to try and adapt to this novel procedure.
Thank you. I was waiting for that one. I was previously involved in a case about a terrorist attack in Lebanon, in which the accused were not present. And in that case, because the statute of the tribunal specifically allowed for the accused to be tried in absentia, there were provisions that dictated that if counsel ever met one of the accused, he would have to withdraw from the case. And although that is not explicit at the ICC, I think we all understand that if we had any contact with Joseph Kony, that would be the end of our mandate. Because, as I think I said earlier, technically I think we are assigned by the court. Once we have instructions from Joseph Kony, we are then his lawyers. We transition from being lawyers appointed by the court to preserve his interests into his lawyers proper. So the answer is, I can't do that. Were he to seek to contact us, I think we would be obliged to inform the court, get some sort of written power of attorney from him, and change our mandate completely. And all of this would then, I think, have to start again on a different basis. So that is that's the situation. Willingness, that's a different issue. I haven't really thought about that because it hasn't arisen. Obviously, it would be dangerous, and yeah, that's a thought for another day. But at the moment, were that to happen, then I suspect we'd have to go back to square one and start again with somebody who was directly instructing him. The strategy is to protect his legal interests in the confirmation of charges hearing. And that may involve further legal challenges to the legality of the proceedings, the validity of the proceedings, and maybe certain arguments about the construction of the charges and whether they are legally proper. But it is unlikely to involve the presentation of a positive defence case because we haven't got instructions to do that. And Kate's already raised this very valid point. For all we know, if he were here, he may well say, yeah, I did all that. Or I did some of it. I accept it. And if that were his position, then he would be entitled to credit for that acceptance. And if we take active steps to argue that he didn't do this or he didn't do that, then we're actually harming his interests. Do you understand that? We're actually, harming his interests in the future, possibly. Did you say, do I think I'm gambling with this case? No, I don't. It was a decision to apply to get it. I didn't know I'd get it, and once I got it, I thought this is something I want to do. It's challenging, it's different, it's fascinating, and at the end of the day, I will be proud to have said that I was involved in it.